With us. Let's bring in Mike Davis, a former law clerk for Justice Neil Gorsuch, former Senate Judiciary Committee counsel and president of the Article 3 Project. Mike, good to have you with us today.
Thank you.
You know, I think it's very clear, and I know it's very clear to Susan Collins as well. She's a very smart woman, a smart senator. She understands what precedent is. But I think a lot of people in the country misinterpret when they hear someone in a hearing say that something is settled law. And here are some examples of those moments from the nomination process for now Justice Gorsuch, Justice Coney Barrett, and Justice Kavanaugh. Watch.
I would tell you that Roe versus Wade, decided in 1973, is a precedent in the United States Supreme Court. It has been reaffirmed.
It's settled as a precedent of the Supreme Court entitled to respect under principles of stare decisis.
Roe is not a super precedent because calls for its overruling have never ceased, but that doesn't mean that Roe should be overruled. It just means that it doesn't fall on the small handful of cases like Marbury versus Madison and Brown versus the board that no one questions anymore.
So none of these individuals, Mike, sat at that table and said, if a case comes before me and I am a justice, that they wouldn't evaluate it and make a decision on whether or not Roe v. Wade would hold in light of their decision on that case, correct?
Correct. So I ran Justice Gorsuch's confirmation effort from the outside. I ran Justice Kavanaugh's confirmation effort from the Senate Judiciary Committee, and I was very involved on Justice Barrett's confirmation effort at the Article 3 Project, and I worked on the Chief Justice and Justice Alito's confirmation in the Bush 43 White House. This is how Supreme Court nominees always answer these questions on precedent, because they're bound by judicial canons that say that they cannot exchange their future vote in a case for a confirmation vote by a senator.
Yeah, and Susan Collins' office says that she never asked for, nor did she receive any promise from Brett Kavanaugh that she wouldn't do that. Obviously, that is unethical, and it's actually illegal for them to make that kind of commitment. That's not the kind of world that we live in here. So, you know, but she is saying that she thinks that this is a divisive decision, I should say, and that she believed that it was incumbent on the court to lean towards consistency and restraint given the division in the country. And I think that what's interesting about that is that it isn't too far away from what we heard in Justice Roberts's concurrence on this opinion. He wanted to simply support the Mississippi case individually and not have it have the broader ramifications that this decision has, I think for somewhat similar reasoning. I think that's fair to say. Your thoughts?
So they uphold the 15-week ban in Mississippi, and then the state passes a 6-week ban, and then we're back to where we are now. I think what the 5 justices on the Supreme Court did correctly was follow the Constitution. They ripped off the Band-Aid, and they got rid of nearly 50 years of bad precedent that has unnecessarily divided our country. Now abortion regulations go back to the 50 states, and our elected state officials can decide abortion instead of unelected judges on the Supreme Court.
Mike, thank you very much. We've got to get in some breaking news here. Thank you. Mike Davis.